And we're back. Hello, everyone, again. We are here for part 2 of this event. We've had a lot of fun in part 1. I hope many or much of you were able to be there and can stay with us at this point. I'll be moderating this part of the event together with Johnny. We have a truly unbelievably stellar panel to discuss this part 2. I will just name names, but of course you are familiar with each and every one of them. We have Andrea Coscelli, the Chief Executive of the UK CMA. We have Elizabeth Denham, who is the UK Information Commissioner, as well as the Chair of the Global Privacy Assembly. Andreas Mundt, President of the German Cartel Office. Rebecca Slaughter, Commissioner at the US Federal Trade Commission. Wojciech Wiewiorowski, who is the European Data Protection Supervisor. Chris D'Angelo is Deputy Attorney General in New York. And last but not least, Henri Pifot is the Vice President of the French Competition Authority. So a fantastic collection. And what we want to do here is to build on the discussion we had in part 1. The discussion in part 1 was about asking data protection and privacy experts the question, what is it that the privacy experts see that the antitrust agencies often, not generally, the people we have here are exceptions, but generally don't see quite in the same way. And that really is about making the point, of pursuing the point that ultimately when we care about the digital economy, protecting consumers, this involves both dealing with market power and enforcing privacy and data protection rights, but not separately. The whole discussion we had earlier was about the importance not to just pursue a weak notion of intersection, but one of integration, because these two points of view are very close. And indeed, we need to develop in the antitrust world, which is one I know best, this notion that when we think about theories of harm, theories of exercise of market power, we need to really integrate that perspective, because that market power is solidified and extended by violation of data protection. So I really want to pursue this conversation because I think while the people here are an exception, I feel too often when discussing with agency leadership even, I get this sort of message back that says, but you know, we do market power over here. We don't do data protection. There are other data protection agencies doing that. That is kind of consumer stuff, and we don't really need to get too involved. And I don't think it is conceivable at this point that we can still think that. But fortunately, of course, the people here, as I said before, are an exception. We have had as the direct occasion for this event a pretty groundbreaking statement that has been put together and issued jointly by the CMA and the Data Protection Agency, ICO, in the UK, which has actually made the point that these things should be thought through and of in an integrated, holistic way. So I want to jump into the discussion straight away. I think that I'll hand over to Johnny to just set the scene for Andrea, who will tell us about his views of the statement, what motivated it, and his position.
Thanks, Christina. Andrea, this statement is remarkable. You talk about the strong synergies, I'm quoting from the statement, between the interests of data protection and competition, and you're striving for regulatory coherence. And I'll quote another chunk. You say the objectives of competition law and data protection are sometimes characterized as being in opposition. We do not agree. This is what you both say together. There are fundamental synergies underpinning our respective policy goals. Can you give us some concrete examples of cases where you and the ICO, who have made this statement together, are working together in that way?
Yes, thanks, Johnny. Let me just make a couple of preliminary points, and then I'm going to get to that. So, first of all, thanks, Christina, for organizing this. I mean, I think that there is a clear division of labor, and it's very used for, managed to watch most of the previous panel, and I think it's very important for us in our institutional roles to kind of be constantly pushed to think through the substance of what we do or what we don't do. And this is clearly a relatively new area where, a lot of the thinking and the work of others is really relevant. And in particular, I think there are 2 points from the previous panel that I thought were very strong and that I agree with. One was, John, is your initial point about the problems with under-enforcement. So one of the reasons we are today where we are is partially historic under-enforcement by competition authorities on merger control. And that's a theme that is extremely interesting and relevant to us because obviously after the exit from the EU, we now have a bigger role in merger control on global mergers. So it's certainly very important to us that we take the right decisions going forward. And secondly, I think your point about under-enforcement by data protection authorities, obviously that's not something I have direct impact on, but I think there's a general theme there, which is as a competition authority that works across the general economy, and I spend a lot of my time working with the regulators in other sectors, quite often we intervene in areas where there is under-enforcement by regulators in specific areas, and I think that's to be one of the synergies. In a sense, if you think about well-designed systems where you have vertical regulators in specific sectors and horizontal regulators like us or the ICO, we are more successful at doing our job if the vertical regulators do their job, and I'm sure they're more successful if we do our job properly. The second point, I think, which I thought was very powerful, was Dina's statement about the conflicts of interest and how difficult it is to police very complicated situations. And I think that really resonates with me, and I think it's something for all of us who have merger control powers to bear in mind. We are constantly looking at vertical mergers, conglomerate mergers, where again, historically, I think there has been under-enforcement, and I think we systematically underestimate, I think as Dina said, the ability of companies to work through whatever behavioral commitments or arrangements are offered to us. So I think these are very important points. Going to the statement, I'm pleased to say we've been working very well and very closely with Liz and her colleagues for a couple of years now. It started when we were working on the online market in the UK. It became very clear to us when we started working on it that there were very strong synergies. There was a lot for us to learn from the Information Commissioner and her team, and since then we have developed that, and in many ways I think it's important for people to bear in mind that there is a degree of fluidity at the moment in a number of areas here. One is the substantive one, in a sense we're all learning, and in a sense these statements have to be seen in that context. But also from an institutional design point of view, again, Liz and I, with the head of our communications regulator and the head of our financial services regulator, have set up this digital regulatory cooperation forum, very much to try to have in-depth exchanges of staff and work together in overlapping areas, because we recognize that there are lots of new things happening. We inherited, all of us, good agencies, but good agencies that were designed to deal with a different type of issues. And who knows where we're going to be in 5 to 10 years' time in terms of institutional design. And I think it's very important that we try to work together now, see whether we can flex our agencies and work together productively, but also be open-minded about whatever future institutional design is there. So I think it's a policy, but also it's the nuts and bolts of institutions. I think in terms of the statement, there are a few key points. One is the fact that we believe that if you enforce data protection and you empower consumers, you're more likely to have competitive level playing field, which is clearly not what we have today on the market side of things. We also make what I think is a very important point, which is, again, I think, Johnny, you are referring to it, which is that from a data protection point of view, really, there isn't a difference between the data transfer within a large corporation that owns a number of companies and across different companies. And that's an area where, because it's different from the way we think about it from a competition point of view, I think it's an area where historically we've had some issues and has created some misunderstandings in some of the relationships between data privacy regulators and competition authorities. So I think that was an important statement to make. In parallel to that, again, and I think Simeon covered really well, the work we're doing on the Google Privacy Sandbox that, again, Liz and her team are very closely involved in. And we've been very clear from day one that this kind of oversight role that we're going to play is essentially a joint oversight role. So even if technically it's a Competition Act case, so the legal powers sit with us, substantially we've been very, very clear that it's a joint exercise. And then my final point is, again, in terms of institutional design, as you know, we are in the process of trying to do a similar exercise to the DMA in the UK, and we have these proposals to our government about the Digital Markets Unit, which at the moment sits with us in shadow form. And again, if you go through that kind of advice, it's very clear that whenever we think about data remedies, remedies about online choice architecture, default settings, we very clearly envision working very closely with the ICO to try to internalize whatever trade-offs might be there. In some cases, we might not find trade-offs, and that's easy. In some cases, I think we will jointly try to work out on balance what is the right solution. So, that's kind of where we are. And again, the final point for me, again, this is in the context of a competition authority that deals with a medium-sized economy. So some of the points Dina made about structural separation, they absolutely resonate with me. But the reality is that it's probably more realistic for the US agencies to be in the lead in terms of structural separation if and when it's appropriate, rather than for an agency like ours. So again, there is a lot of international cooperation, but to some extent, probably our higher appetite for regulation is also linked to the jurisdictional angle compared to what might be a dialogue in the US at the moment.
So let me pick up from there, Andrea, and thank you for that. Of course, this statement is important, and it makes a series of essential points, in particular where you both push back against this kind of old kind of narrative that there is an inherent tension between competition and antitrust and data protection, which is something we do not want to hear anymore. You also talk a lot about institutional design, which in your role is, of course, front of mind. But I also want to pursue your views. You're also an economist, and of course, this event is in the context of an initiative that we want to push and motivate economists in particular to really kind of be more alert and awake to the importance of this dimension. So you talk in the statement about intersection and synergies, but my sense is that we could go even further. I'm not making a point about semantics, but I'm making a point of substance. So what we still, I think, are behind, and Alessandro Acquisti sort of covered some of that, is a notion that when we develop theories of harm on the part of some regulators, and Andreas is an exception, you're an exception, but generally, we develop theories of harm in which we go after the conventional economic kind of conduct issues that we know how to deal with. Okay, so there is a bit of exclusion, a bit of foreclosure, a bit of margin squeeze. That's what we kind of see. And then we sort of don't nail the fact that some of this is actually really powered up by these data data control and violation of privacy. So we sort of go as far, fellow economists go as far as to say, oh, data is a dimension of quality. Can we not sort of go beyond that and really think this is like a direct consumer effect? In other ways, we worry about market power increasing prices. This is like a price increase because it degrades the experience of people who are essentially trading their data for what they get. Can we not think more actively and proactively about this as economists and as agencies in competition?
Yeah, so I think we are in the CMA. I think it's a combination of a number of factors. One is there are sort of a risk appetite point, and different agencies are in a different place on that. As always, trying to evolve the case law and the type of approach you take to cases brings some risks. And I think the leadership of agencies has to drive that change, and obviously different people have different appetite for it. I think merger control is highly relevant to the discussion here. So one of the points about particular remedies, behavioral remedies, we are being on record, and I think Becca and Andreas, I'm not putting words in their mouths, but I think they're brought in the same place, that you can't just put all of these risks on consumers. You can't have a complicated merger which would work out only if very complicated remedies come in that needs to be monitored and supervised, and only if you get 10 out of 10 in terms of implementation, then you go back to where you were pre-merger. I mean, our view in the CMA is these things are highly unlikely to happen. I think, as Dina was saying, we have plenty of evidence from financial services where even if you have people sitting together or in the same building or in the same company, and there's a lot of money at stake for them to make, people will cross the line, will have conversations they shouldn't have, and so on and so forth. So I think this is a very real discussion, and as you know, we are quite focused on merger control at the moment. So I think that this will play out in specific cases. I think on Google Privacy Sandbox, if you look at the document we published last week, as Simeon said, we're very explicit that the likelihood that the future methods employed by Google will satisfy that data privacy regulation is one of the key criteria. So we are explicitly saying that, again, whatever a future package that will be satisfactory to us legally should be a package that is highly likely to deliver compliance with data privacy regulation as well, which I think is also quite new. So, we are doing that. Are we exactly where I think we should be? Probably not, and it's work in progress. And I think I'm certainly very happy to be challenged. And as I said, it's not an area where we think we've absolutely worked everything out. It's an area where we're still learning, and then it's an element of learning by doing. And that's part of being here. That's part of working with colleagues, both internationally and domestically.
Thank you for that. And I appreciate in particular also the reference to mergers, because I think we're all aligned, certainly on this panel, that much of the issues that we have been facing in this space have come from mergers where the potential effects of data accumulation is not being dealt with, and then dealing with it exposed becomes particularly difficult, as we all know. Let me move on to Elizabeth, because she is, of course, also signing this joint statement. And it is important in this debate to have the perspective of Data Protection Agency. So give us your perspective, Elizabeth, about the motivation for this statement. How do you actually see the work that you're doing together with the CMA, but more broadly, the need for data protection agencies in general to become really part of the conversation when it comes to antitrust and not just operate in silos? This is something I believe passionately, but I would like to hear you setting out your views.
Yeah, thanks very much for that challenge, and also for the invitation to be part of this panel. I think it's really, really exciting. Usually I violently agree with whatever Andrea says, and certainly we're on a journey together. We have a lot to learn, and I want to underscore what he said is that we're learning by doing through real cases and real work. So what we have going on in the UK with the DRCF, which is the wider collaboration with our communications regulator and the Financial Conduct Authority, but certainly the work that we're doing with Andrea right now is learning by tackling real cases like the Google Sandbox case. But I just want to add a bit of color to the statement, because we didn't just create this collaboration 3 months ago or even 6 months ago. So this collaboration really represents over 2.5 years, I think, Andrea, of work between our teams. And if you can imagine it, we've got economists talking to fundamental rights experts and really trying to teach each other and learn from each other the basics. And so it really was an iterative process to get to a place where we could recognize where some of the tensions were, and we were able to break them down to a place where we did realize we had more in common than we had that differentiates us. So a lot of work. What we have going on is not a tea and sandwich club. It's not a quarterly conversation between chief executives. It is actually seconding each other's staff. I just stole Andrea's general counsel, who's a competition expert, now working for the ICO. I think that's really healthy, and happily he thinks that too. But it's secondments, it's a work program. And you asked me the question, what was the motivating factor for the ICO to collaborate strongly and get out of our silos and work with our fellow digital regulators? And I will say that what scared the hell out of me was the policymakers, the legislators, floating the idea of one regulator for the internet. I mean, what does that mean? And so I think what the regulators did is we got to work, we got busy, we became creative, got out of our silos to try to tackle these companies, the likes of which we have never seen before. And I really think what we have done in the UK, and you know, I'm excited if others think it's a blueprint for something that'll work in their jurisdictions. But I think what really pushed us is that we needed to show policymakers and the public that we had our act together. And I think consumers and citizens don't really care if the solution they're looking for comes from the CMA, or if it comes from the ICO, or if it comes from Ofcom, our communications regulator. They just want somebody to have their back when it comes to protection of privacy and protection of markets. So, you know, I just think what we've done, and we'll make mistakes along the way, but I think what we're doing is we're trying to use our regulatory levers in the most creative way possible to be able to make the digital markets work and protect fundamental rights.
Great, thank you for that. And I want to, though, pursue you a little bit along there, because, of course, what you say is clear and important. You and Andrea are proceeding in a closely parallel fashion and quite integrated, as we heard. Nonetheless, I think that, and this isn't a criticism levied at the ICO, but more broadly, when you think about the way, the position that data protection agencies are in, there is a wide narrative out there that the GDPR, for example, is not being enforced as powerfully as it could be. Now, my personal view is that, as you said at the beginning, you've inherited a certain sort of circumstances, and most importantly, not you as ICO, but data protection agencies are effectively now have been expected to go out and fight digital giants with enormous market power, with enormous resources, with the capability to prevaricate in a way that is uneven in terms of your ability to push back. But isn't the original problem here, and this is to you, but of course Andrea also can jump in, isn't the original problem here that somehow in antitrust we fail to just deal enough with the market power, and now you are supposed to be dealing with the consequences of that market power in terms of exploitation and data protection violation in a way that is so uneven? And shouldn't you therefore be clamoring, not you personally, but generally the data protection agencies with the antitrust regulator and say, we can't really do this unless you help us really break down the market power even more strongly?
I listened to a little bit, Christine, a little bit of the panel beforehand, and I certainly heard the challenge that data protection authorities have under-enforced when it comes to the GDPR, which is a new law, and data protection authorities have not had strong powers until 2018. Most data protection authorities in the EU had no experience with administrative monetary penalties, for example. So it's a new law, but I've also heard criticism about the competition authorities actually getting with the program, that data is such a huge asset that it really needs focus on M&As, for example. But what I think it's a waste of time for us to blame each other's communities, to say, how the hell did we get here? We got there because the data protection authorities have under-enforced, or the competition authorities haven't got with the program and understood the value of personal data. So we can't blame each other. I think what we need to do, and leave it to historians to go back in time and say, this is where it all broke down. And I think our energy should go into what's the solution in the future. And I think our institutional boundaries, there's a question mark, what we're going to look like as oversight agencies in the next 5 years. But I think what's really healthy is if we don't argue about turf, we don't argue about under-enforcement, and we collectively tackle the issues of big tech. So what I'm trying to do, and I'll leave to others to discuss the dialogue about harms and breaking down harms, and which authority should be on first when it comes to tackling a specific problem. And I think we need to find ways to integrate, collaborate in real ways on real cases. And one more point I'd like to make is in what I think is really important and a blueprint or a pathway forward is that the ICO and the CMA were together at the start of looking at the Google sandbox. So it wasn't the ICO coming in at the end of the day and providing some advice, is that we were there from the start of an investigation. And I'll leave it to Wojciech maybe to tell me differently, but I think that's a first for a real case, a big tech that had both competition and data protection issues, and we worked on it together from the start. So that's what I think is the path forward for data protection authorities and competition authorities.
Yeah, and thanks for that. And I certainly emphatically agree that this is not about apportioning blame. It is about looking forward and how to get things right going forward. Johnny, do you want to take the next?
Yes, Andreas. Yes, let's turn to Andreas. Andreas, you have been leading the way with some very interesting orders and actions and thinking going back quite some time. The Bundeskartellamt treated Facebook's data merging and aggregation from multiple sources into super profiles as an abuse of dominance. And you framed these data-related practices as a matter of competition law. And there were two things there. The violation of data protection law now amounted to an abuse of dominance by Facebook under national competition law rules. That's interesting. And second, that reduced choice for users was a reduction in competition as a direct effect on users rather than also just as a reduction in competition between undertakings. Now, that's the past. What I want to ask you about is what's next. Germany has been leading the way, but now you have 19A of the new GWB Act, which came into effect in January. And maybe you could share with us your vision for how you're going to use 19A in the digital market to make all of our problems go away.
Yeah, many thanks, Johnny. I must correct you. The past is also the future. Because this Facebook case, I'm not going to go into the details now. It's always been a big case. And now it is up to the European Court of Justice to say something on that case. I will come back to that. But if everything works well, we might get a very clear ruling and saying by the European Court of Justice, as far as the ECN is concerned, in how far we can integrate GDPR in assessing competition matters. Facebook has always been a big case, but it might get even bigger in a certain sense. Another issue, Christina asked me to talk about integration, not just intersection. I mean, if you look at the Facebook decision, it's around about 300 pages. The first 100 pages are about competition law. The third 100 pages are about competition law again. And what is in the middle, 100 pages, are about GDPR. So if you ask for integration, I think the Facebook case gives you an excellent picture of how you can really integrate these two fields of law, which from my perspective really belong together. Before I come to 19A, maybe a few words on the questions that the European Court of Justice might answer. I mean, the Facebook case has been subject to judicial review in any kind of already. We had a first instance at the higher regional court in Düsseldorf, a preliminary proceeding. From there, we went to the Federal Supreme Court in a preliminary proceeding. The Federal Supreme Court mainly supported and confirmed our findings. We went back to the higher regional court with a second preliminary proceeding, just to make you aware how difficult it might sometimes be to get these kind of cases through courts once you have brought them to an end in your agency. Again, we had to go to the Federal Supreme Court with the second preliminary proceeding, and then we went back to the higher regional court in the main proceeding. There we were, finally, beginning of this year. And what did the higher regional court do? It referred the case to the European Court of Justice after, 3 years in judicial proceedings. The first time I thought, oh my gosh, this is going to take years again. We might write law history in the very end. But I mean, another year, so to say, another decade in the digital economy. But then I took a very careful look at the questions that the European Court of Justice has to answer now. And I simplified that a little bit. But in core, there are three questions. The first one is, can the Bundeskartellamt establish GDPR violations when weighing interests in competition law? So you see that really goes to the heart of the problem. The second question, and that is maybe even more important, is user consent really voluntary in light of Facebook's dominant position? So here it gets really entwined, competition law and GDPR. And maybe most important, the third question, what lawful grounds under the GDPR can Facebook invoke to justify collecting of Facebook data? Again, a question that, from my perspective, you can only answer if you give your answer half competition law, half privacy provisions. So in the very end, I must admit, it might take some time now in Luxembourg. On the other hand, this is the opportunity for the European Court of Justice in whichever direction, but it will be clearer afterwards in how far competition law and GDPR go together and in how far we can take the assessment of one field of law to make a decision in the other field of law. And I think this is most interesting. Luckily enough, if we had to decide, and this really takes me to your question, if we had to decide the case today, I can imagine that things would be much easier. You know, we have a new Section 19A in our amended competition law. It came into force by the end of January. It's a provision with a two-step approach. The first step is that we have to designate companies with paramount significance for competition across market. It sounds complicated. In fact, it's nothing else than a core platform or, Andrea, a company with a strategic market status. It fits into our system of law this way. One key parameter when assessing that is access to data relevant for competition. Again, this is said in German competition law, in how far we have to take data questions into account. Once we have designated a company to be of paramount significance, we can prohibit certain conduct much more easily than we could in the past. We can prohibit, for example, that a company impedes other undertakings by data processing that is relevant for competition. We can prohibit that a use of service depends on the agreement to data collection with no choice. This is the Facebook case, indeed. So what do I want to say? When this law was negotiated in Parliament, Parliament very much referred to the Facebook case, and in a certain sense, this entwinement of competition law and data protection law is written in a theory of harm in the German competition law. Now, at least this is my interpretation of it. And I think I said that again and again. This makes a lot of sense. I mean, if we talk about dominance, and if we assess that this dominance has come into place because of data collection and data possession and data processing, you need a parameter in how far a company is allowed to gather the data to process it. Of course, we could then, as a competition agency, develop our own parameter, what is allowed and what is not allowed. But, excuse me, the legislator has already taken a decision on what is allowed and what is not allowed, and that is in GDPR. So it makes a lot of sense to make use of a parameter that is already in place and of which at least the legislator thinks it's an excellent idea. There are more issues in the law that will facilitate our life, at least I hope. It is still possible for companies to bring reasons for justification of a behavior, but then the burden of proof is on the company, not on us. They have to prove. They have to provide all the information we need to assess the case. I think that helps very much. And the best thing, I never dare to dream of it, I always said, if you want to speed up proceedings, don't only look at the proceedings before the authority, also look at judicial proceedings. I just pointed out how this can develop. So we have a new provision in the law that decisions based on Article 19a go directly to the Federal Supreme Court in Karlsruhe as the first and last instance. This in itself spares us 1.5 years in critical cases. So I think this is an excellent idea. To conclude, we have very quickly made use of this new provision. We have initiated new proceedings against Google, against Amazon, against Facebook. We are assessing Google's data processing terms now. We examine how far terms allow data processing, how far these terms go. We look at how data policy of Google relates to processing data from third-party website. And we will take a very close look at the question if Google offers users a sufficient choice when they make use of Google, exactly along the line that the Federal Supreme Court has sketched out in its preliminary ruling. So, firstly, I'm deeply convinced that you have to be innovative in this sense. I know how difficult it is because you have to persuade the courts of being innovative. That is not easy. Christina related to that. But for me, this case is so important because, to be very frank, I do not want to discuss with the parties about the design of a website. Does it need to be in red, in blue, in gray? Is that self-preferencing if it's gray shade 8 or shade 9? I want to go to the core of the problem. And I think with this inclusion of data assessment and dominance assessment, we will be able, I hope so at least, to tackle the dominance of these huge data-driven companies. And this is what we want to go for. And I hope that the law allows for that.
Bravo, Andreas. I just have this terrible fear that you're overlooking a color called transparent, which the opt-out button might be. Back to Christina.
So I'm so glad that you said all that, Andreas, because indeed I credit you as being a pioneer in this space when you started the Facebook case and the integration, the sandwiching of the GDPR inside antitrust, as you said. There was nothing like that out there, and it created quite a lot of consternation, but it did certainly embody some sort of vision that things needed to move in this direction. And indeed, this is, I think it's entirely positive that we're going to wait for the courts to pronounce on this. You never know which direction the courts can take. But of course, you have also the now 19A as a tool that you can use in future to pursue your cases. So we'll go back to this. And to you in the second round, but I want to bring in now Commissioner Slaughter. Rebecca, you at the FTC have been very much a personal advocate for the integration of antitrust and privacy, and the FTC is pretty uniquely placed because the kind of powers that Congress has given you are quite expansive to deter deceptive practices and so on. Now, of course, there are also critics, voices that say that the FTC has not used these powers quite as effectively or expansively as it could. Yes, there is a settlement with Facebook, which has been seen as something that doesn't quite adequately deter, and I know you've been a dissenter on that settlement. Now, looking forward, there is work to do, of course, but where are we? How do you see this integration? What do you see as the future? How do you see the next steps? How do you think in the next few months and years this particular narrative will develop, and what do you believe should happen?
Thanks, Christina. It's a great question, and you're right. This is something I've been thinking about and talking about for a long time, specifically in the context of what the FTC's authority and mission is. I will confess that when I got to the agency, one of the things I found the most surprising was how incredibly siloed our competition and consumer protection enforcement missions were and staff, excuse me. And the fact that we would have sometimes multiple investigations, often multiple investigations of the same large firm happening at different places in the agency simultaneously without being integrated and coordinated was really surprising to me. So I think what Liz and Andrea are doing is great with respect to their agency's specific powers, but we have all of that in-house at the FTC, and I think we need to be capitalizing on it. And in fact, you pointed to my dissent in the 2019 settlement with Facebook, and what I wrote there specifically was that I was skeptical that the terms of that settlement, $5 million notwithstanding, would have a meaningful disciplining effect on how Facebook treats data and privacy, and that I couldn't view the order as adequately deterrent without meaningful limitations on how Facebook collects, uses, and shares data, or without public transparency about that. And what I said a little bit later was that the failure to impose any of those substantive purpose limitations and use limitations on Facebook's collection of data from both users and non-users would, in addition to allowing Facebook to aggregate rich data stores across its platform unfettered, would also exacerbate competition concerns, and that we should strive to make sure that our enforcement efforts are integrated in that lens. So that's where I was 2 years ago. That's exactly where I think we need to be going. You know, what I think you're right that we have a bunch of tools we haven't capitalized on. In my time as acting chair, I set up a rulemaking group to start to work in that direction. I think we need to do that. I also think that, you know, I think that rather than having a separate agency, as Liz said, to deal with the internet, which I agree, that's a big mandate. But I do think we could benefit from like a digital markets bureau at the agency that takes an approach to an integrated approach to the big cases in digital markets. And I think that would be an exciting way to push forward in this area and make sure that we are integrating those questions. You know, notwithstanding all of that, we had our 2019 settlement. We have an existing order. I didn't think it goes far enough, but I do think we need to enforce it, and we need to help effectuate some of that public transparency around compliance. And if we find that Facebook has violated that order, I think we should make very clear that the terms of the original order weren't enough to change the behavior, and really pursue remedies that will be effective in going to sort of the root causes of the data abuse that we are worried about from both a competition and a privacy settlement perspective. And then the second point that I would make is that we have our outstanding competition case with Chris and his colleagues in 48 different jurisdictions. And I want to express my profound appreciation for his partnership and his boss's partnership on that case. It's been tremendous, and I feel really glad that we are in a position to do this work together with a lot of synergy and enthusiasm. So that case is pending. We will see where it goes, but I think that I'm hopeful that it will pursue, you know, the headlines that it has gotten is about breakups, and those are important headlines. I think structural remedies are important, but I don't know that they solve the entirety of the problem without getting to, again, these root causes. It all, to me, comes back to putting guardrails around how data is collected in the first place, stored, shared, used, and that will help protect privacy. It will also help protect competition, and that those two things are totally aligned.
So this is great, but let me just pursue you a little bit and challenge you a little bit on this. So and this goes also to the discussion I want to have with Chris. So you mentioned the Facebook complaint, which is a great piece of work, and it does aggressively target the past mergers. But even then, so the remedy that is being pursued is mainly divestment, of course, of certain assets. And to quote someone like Maurice Stuck, who wrote an article about that, one point of view is that the complainant's prayer for relief does not seek to give users greater control over their data, Understanding that a complaint has got a slightly different lens, but the issue is really how to deter Facebook data hoarding, surveillance, and manipulation, which is the final objective. So where are we? So you talk about, of course, wanting to bring together and integrate these capabilities that you have. And you have a patchwork of acts and various other state laws and constitutional claims, but you don't have as yet a privacy framework that is comprehensive at the federal level, like we have the GDPR, and there's even a body of opinion in the US that finds it very fashionable to just snipe at the GDPR and say it doesn't work. So how do you see this sort of objective being pursued?
Yeah, thanks. So first of all, let me start by saying just the nature of litigation is that one doesn't always put out all of the remedies that one would hope to see at the end of a case in a complaint. So I wouldn't read that as dispositive about what we would seek. And I will let Chris speak for the states, but I'm guessing we're pretty closely aligned without putting words in his mouth about wanting to make sure that remedies really do get to root causes, are adequately deterrent, keep us from ending up back in the same position again and again. Because that is what is the most galling to me about the state of markets right now, that even where we take action, in our best faith, good public servants working hard to take action, we keep coming back to the same questions again and again, which means that the action we're taking isn't working. We need different action to keep us from having the same conversation again and again. So I wouldn't overread the complaint as dispositive with respect to remedy on that point. But I will take your question about where is the US from a general policy perspective framework, and push back on one thing that you didn't say, but you referenced, which is that we need to give users more control. I want to sound a note of caution about approaches that are centered around user control. I think transparency and control are important. I think it is really problematic, and Andrea referenced this earlier, to put the burden on consumers to work through the markets and the use of data, figure out who has their data, how it's being used, make decisions. I mean, I think you end up with notice fatigue. I think you end up with decision fatigue. You get very abusive manipulation of dark patterns to push people into decisions. So I really worry about a framework that is built at all around the idea of control as the central tenet or the way we solve the problem. I'll keep coming back to the notion that what instead we need to be focusing on is where is the burden on the firms to limit their collection in the first instance, prohibit their sharing, prohibit abusive use of data. And I think that that's where we need to be focused from a policy perspective. I think there will be ongoing debates about privacy legislation in the US. And while I'm actually a very strong advocate that we should have better federal framework with more tools that facilitate aggressive enforcement. But I think if we had done it 10 years ago, we probably would have ended up with a notice and consent privacy law. And I think that would have not been a great outcome for consumers at the end of the day. So I think the debate and discussion has evolved in an important way that's good. I also think we don't have to wait for Congress to act. So one of the things I said when I set up this rulemaking group and when I talked about what I think we should be doing with it is we do have rulemaking powers at the FTC, and we should be using them. In September of 2019, I gave a speech about the FTC's authority to do consumer protection rules, which is called MAGMOS, and it used to be called MAGMOS. We were referring to it by its statutory name, which is Section 18. And nobody likes it because it's more burdensome than normal rulemaking processes at other agencies. But I have been saying for 2 years, that doesn't mean we don't try. We build the process, we use the tools that we have, and we try to, in an inclusive, participatory system that gets stakeholder input, advocacy input. We can consider a record, economic evidence, other evidence, and then move in the direction to see what we want to see. So I think we should do that as a matter of policy. I also think we should push for those terms in our litigation and in our settlements to the extent we get them. And then I will just sound a last note of caution that because what I want to do is get to root causes, I don't think companies are going to want to settle on those terms. I think we should just expect that companies are not going to agree to something that hurts what has been a very effective money-making machine for them. And so I think we do have to expect that there's going to be more litigation around that. That's what I would have done with the 2019 order violation, was just sued them. And that's what we did with the antitrust case. So I think it's fair to expect a lot more litigation, and we may run into walls in the courts. Andrea talked through some of their lengthy court process. We have our own challenges in our court processes, but I always want us to be in a position of trying. Like, I want us to go and ask, advocate for what is the right thing to do. And if the courts don't like it, that's a really good argument to our legislature to say, this is a problem with the law, not a problem with will at the agency, not a problem with lack of creative thinking or lack of understanding of markets.
Great points. I'm so glad you laid it all out in that way, and particularly also the shout out and the correction about user choice, because indeed that is a super important point. I could see Johnny nodding. We need systematic solution, not to put the burden always on the individual consumer. I want to move to Chris, because of course he's close to you I could see him nodding as well as you were speaking. Chris, of course, the state complaints on Facebook goes into significant detail. It is so important, even for us, watching the development of this march in the US to greater enforcement, to understand the relationship between and the importance of state level enforcement together with the federal agencies. This has been a phenomenon that we've watched with great interest in the last year or so. We've seen this great complaint. Certainly bipartisan complaints moving ahead. And the Facebook one that New York is in the lead of is particularly interesting because it does lay out the way in which gradually privacy is being degraded as a result of the increase. So the complaint is one of those that really makes this case about privacy and antitrust being so closely related most effectively. So give us a view about it from your perspective, not just about the complaint, but more generally about this interplay, this integration, privacy, competition, and antitrust, and also a bit about more thoughts that you may have on the need for federal law, federal framework. That going to advance? It should, but is it going to be also something that could undermine the effort? Take it away.
Sure. Thank you so much, Christina, for organizing this event and for giving me the opportunity to participate. And I will say I'm excited about the opportunity to have this conversation because this, to me, is precisely the policy debate we need to be having. There is really nothing more important, in my view, than this integration between privacy and competition, how we address the many important policy issues that are outgrowths of that collectively as both antitrust enforcers and as data and privacy enforcement arms. I have the benefit in my role of overseeing both our data and privacy work at the New York Attorney General's office and the antitrust work. And one of the things that was very important to me when we were building this investigation with respect to Facebook and the other big tech investigations was to make sure that I had both people on my team that were privacy experts and people who were competition experts working together to build our investigation and to think about how to frame up our complaint and our claims when we ultimately brought it. And I think you see that, as you noted, in the ultimate complaint that we filed here. And we were explicit about going into detail about how Facebook over time has degraded its privacy protections, degraded the control that consumers have over their individual privacy. And to us, that was important because that's the whole ball game here. at the end of the day, these companies make their money through profiting from the information, the data that consumers provide to them. And that is the means of exchange for these companies. That is the, as you've said, the price that is paid by consumers in exchange for using whether it's the Facebook service or other online platforms. And so we laid out in detail, and I'll focus on what's public in the complaint, how, at times early in its history, when Facebook faced more competition than it does today, how they took great pains to avoid implementing policies that they were worried might cause consumers to raise questions about their data and privacy controls. And later on, once they had established their monopoly power, they had taken actions to eliminate competition in the market. They had greater freedom and flexibility, even in light of what they had in terms of information about consumers wanting more control over their data, utilizing data control options that had been made available to them, having concerns about risks to their data being used in ways that were problematic for them. Facebook continued to proceed with both degrading the controls that consumers had and increasing the amount of data and the ways in which it was exploiting the data of the consumers, thus raising the costs for those users in using the Facebook platform. That was for us, and we lay it out, establishes both Facebook's dominance, its monopoly power, but also recognizes that it's a harm, it's an increase in cost, an increase in price in the traditional way you think about antitrust and competition law to those consumers who want to use the platform. That was important to us because, one, it really goes to the heart of, as I said, the profitability here, but it's also because, what is going to matter to a judge? I think earlier on, Andrea talked about what our risk appetite should be for taking more aggressive views on how to integrate privacy and data into our theories of harm. In our view, it's necessary, given the multiple decades in the U.S. where competition law has both been under-enforced and interpreted in ways that has scaled it back. In order to make a case like this one resonate with the finder of fact, in order for a judge to want to push the law forward, the case has to matter in some way that's significant to people. And so here for us, the thing that is significant, the thing that caused those of us at the New York Attorney General's office, and I think it's true at the FTC as well, to get up and say we want to spend our resources and our time focused here is really about data and privacy. And so to not include that in the discussion of harm would be a big miss, and I think actually work to the detriment of moving the case forward. I do want to also echo what Becca said earlier. It has been an incredible partnership between the states and the FTC. We are very much grateful for the work we've done together there, and I think we've both, aided and benefited each other's work as we've proceeded alongside one another, and I think we all have the same ultimate goals. I would say the same thing about remedies, as Becca said. I wouldn't read too much into the complaint. We believe we've pled a complaint that is broad enough to cover a whole host of remedies, including divestiture, which in our view is necessary but not sufficient to solve the competition and the privacy issues that are at the heart of this case. But that's something that's really for a later stage of the litigation to really determine precisely what type of remedy is going to be necessary. And frankly, given the nature of litigation, as we've talked about here already, it takes time. And that time means that by the time we get to the point of imposing a remedy in this case, exactly what that remedy should look like is going to differ based on the facts on the ground at that moment. And so we want to make sure we have the flexibility to ask for the right remedy at the right time, given where we are.
Fantastic. And it's so incredible to be hearing agency leadership for such important agencies, the UK, Germany, the FTC, New York, to really be so forward in this debate. We'll hear France in a minute as well, in a way that, we are trying to move that discussion, but you guys, of course, are already there. And we want the broader antitrust community to really buy into this in a proactive and productive way. So let me just hand over to Johnny, who is going to take to Wojciech next.
Yeah, question for Wojciech. Wojciech, the competition and data protection communities make terrible trouble for each other, but they also have remedies for each other too. And digital market and rights problems have metastasized in the gap in between them, and hopefully that gap is closing. I think it was the EDPS that launched that idea, that debate in Europe about more than half a decade ago, calling for coherence in enforcement between those two communities, experiencing what was happening in the market. And I might be wrong, but I think it was Helge Heijmans, who has since moved. And there was this clearinghouse set up to help national enforcers get together and start having that discussion. And first, there's no blame associated with the question I'm about to ask you. The EDPS, to explain to anyone who doesn't know, is in an unusual position in that it doesn't address the private sector, but it has a tremendous moral authority, which was wielded with expert aplomb by your predecessor, Giovanni Buttarelli. And the effort was to try and get these different communities of enforcers talking to each other. Now, since that effort, the problems got worse. So I want to know what happened. Why didn't it work?
Well, first of all, of course, I would like to thank you for allowing me to take part in this prestigious meeting of the persons who know the most about the practice of the cooperation between the privacy authorities, privacy regulators, and the competition regulators. Well, you are partly right that EDPS has started quite a long time ago, because it was 2013, 2014 when we started the whole discussion. But I, of course, have to say that they didn't come from the EDPS only. Actually, the first event that was organized by EDPS in 2013, I guess it was in the end of 2013, was the event which was with the national authorities. And at this time, I was the Polish Data Protection Commissioner, and I was speaking at this conference on the experiences that we had with the competition authority in Poland. But actually, I have to admit that we were rather talking about the consumer protection authority, which just by incident is the same office as the competition authority. But it was always visible then in this in the authority which was dealing with the competition and the consumer at the same time, that this is rather the consumer part which is cooperating with the data protection authorities, not the competition one. And you're right that Hike, who is right now in the Belgian Data Protection Authority, and my predecessor Peter Hastings were actually the ones who started this discussion. But clearinghouse was probably even the more important creation that came out of that at the times when Giovanni Buttarelli was in office. That was also later on summarized by the conference at the end of the Giovanni's term, where Andreas Mundt was the keynote speaker in the Bavarian authority. You rightly said that we are not responsible for the supervision over the market, but that gives EDPS a slightly different role, because we are the supervisor of the institutions of the European Union, but we are also the main advisor in the legislative process. And that's the angle from which we are approaching the discussion, being at the same time a little bit more neutral than the authorities that we have in the member states. Of course, we are right that there are quite a lot of hesitance, both on the side of the competition authorities and on the side of the data protection authorities in going to the real cooperation. Well, sometimes we may say that the data protection regulators are saying, well, you competition regulators, you care only about the efficiently working market, and you would sell other rights in order to buy a little bit oil for the machinery which the market is, while at the same time the competition authorities say, all you data protection regulators, you want to steal our tools, our toys actually, that we created for 30 years of our work, and you want to use them not in the action which they were created for. So for the working on the market, but you want to steal our sandbox and use it for the fundamental rights. But I have to admit that when I was in 2014 starting this discussion between the data protection authorities together with the DPS, I was a little bit more optimistic. I actually thought that in 2-3 years we will go to the situation which is comparable with what we have right now in the UK. So we will have a kind of memorandum of understanding or any other tools that exist, at least on the national level, not even thinking about the normal meetings of the European Data Protection Board and the equivalent of that on the side of the competition authorities. It doesn't work like that. The clearinghouse was a very good place to exchange the ideas, especially about this that we want to cooperate. But when it comes to the real effects of this cooperation, I may say that Andreas' presentation at the conference in Brussels in 2014 was probably one of the most direct example of what can be done. And I don't feel that this development is actually fast enough. So just saying about the other experiences that we may take from these activities, we can say that no effective competition nor protection of the rights in the digital economy can be ensured when the different regulators do not talk to each other and understand each other. And while we are still thinking about the cooperation, it looks a little bit like everybody is afraid that we'll have to trade a little bit of its own possibility to assess. Of course, once again, I may say, I don't talk about the people who are here in this room, because we are all very open and very ready for the cooperation. Are we really? Is it really true, especially if we think about the classical regulators? Isn't it true that at some point we are reaching this border where we can say that we know how to work, we know how to behave, we need a little bit of help and a little bit of understanding of the other regulators' work? Of course, I'm saying about the European approach for the obvious reasons. And what is interesting for me is that there is at the same time the discussion about kind of split of the tasks of the American regulators and joining the ones on the European side. But even the statements of some of the commissioners in the European Union saying about the bigger role that the Commission shall play in the data protection and solving the enforcement problems of GDPR show that there is no clear understanding what are the differences between these fields. Well, I'm happy to work on that, because that is a legacy of both Peter Hastings and Giovanni Buttarelli. But I think I may even say right now that while Peter organized at the end of his term the first conference on the competition and privacy, while Giovanni's last conference was the one about competition and privacy on 9th of July 2019, we will have to summarize the next term of the data protection supervisor on the European level with another look back and to ask ourselves in 2024, have we moved away from the position we had even in 2014 in practice? Well, yes, as far as the knowledge is concerned, but as far as everyday cooperation, I leave it for the discussion.
It's wonderful to have a frank and deeply pessimistic note as we approach the last stage. So let's dig into that pessimism and talk. You mentioned the Commission. We have a few shining lights sparking here on our screen over the last hour. Do you think there's some way to build on Andreas and his cooperation with his counterpart at the Hamburg DPA and on what the CMA is doing with the ICO and so on? Is there some way to build upon that and solve a bigger problem, which is, I suspect, sitting between DG Justice at the Commission and DG Competition, but also DG Competition down to the national enforcers too? Is there some way to build on this?
Well, if you think about the cooperation in DG on the German market, definitely yes. I'd like to remind that this conference from 2019 was organized by the German Federal Commissioner. So this is not only the land commissioners who are responsible for the market themselves who are involved in it, but also the Federal Commissioner. And these are the practical results what we have in Germany. So that's something to build on. I would not want to assess the possible tensions inside the European Commission. That's not my role to deal with it, to discuss on that. On the other hand, if there are different points of views, and there are the different points of views in the Commission, that's good. This is what the Commission is for. The Commission is not the king. The Commission is not the president who has been elected for 4 years in order to realize some political plan. Commission is the representative of different parts of the market and the society, and the interest of that, which have to be gathered together with something which is the core of the European cooperation, the cooperation itself. So this is not the free election of king for the lifetime or for the term. That's the continuous exercise on finding the common way, the common strategy among the countries which are as different as Finland can be from Portugal, and Slovakia can be from Ireland, and that's the beauty of that. But to do that, we should look both on the cooperation that exists between the authorities from the same country, but also some good examples of this cooperation on the European level.
Let me jump in here, and I want to thank you deeply, Wojciech, for making these points. I think you're a breath of fresh air. You are completely candid, honest, and open about this, a reality check. And I think that the things you said are remarkable. For those who may be listening, and indeed the panelists from outside of Europe, what he said was extraordinary and important. We may all talk to each other and think that we're making progress, but in reality, from where he sits on the ground, the progress isn't quite as fast, and there is a lot of work to do. And I'm grateful for you coming out and saying all that. Thank you. Now, I want to turn perhaps, certainly last but not least on this list, to Henri, who is here is the Vice President of the French Competition Authority, another major agency and one which is second to none, certainly, in its commitment to this. You have that perspective. The ADLC is also an agency that does a lot of work with CNIL, the local French data protection regulator. So there is a lot of joint, shared work. And indeed, we know that, for example, we are closely looking together at cases to do, for example, with Apple's privacy policy, their implications for competition. So that is an area that you've spent quite some time on. But you also have a broader perspective, because I know also, again, from experience, that you've been involved in the ICN steering group on this topic. And I've been assisting myself to a couple of these events where the discussion was beginning to move to this kind of notion that we need to think broadly about this integration of antitrust and privacy. So why don't you give us your perspective, what you heard today, and any point you may want to make on this particular point?
Sure. I mean, hi everybody. Good morning or good evening, depending on the time zones. I'm the icing on the cake, so I hope that the cake will be very digestible to all. There's perhaps one point I would like to make, which is we should be perhaps careful and not to be too simplistic in making an equivalence between say variations in the degree of privacy protection and the variations in prices. It all depends. I mean, the key question here is really what caused the variation in privacy protection, or what caused the variation in prices. It may be that it's a market failure which is linked to market power, and then indeed there would be possibly a case to be looked at from a competition law perspective, or it may be another type of market failure, and then competition policy or competition enforcement, at least competition enforcement, wouldn't have anything to do with it. So you may end up with cases which would be dealt, raising the same issue, which would be dealt by the Privacy Protection Agency and some others, which would be dealt possibly by a competition authority. But so there is already here a question to ask ourselves: why is it that some cases should be dealt by one and not by the other? And why is it that we ask ourselves this question at the very least? Then, if I look at cases where there are issues of policy of privacy protection, so it could be cases where there's an increase in privacy protection, or there could be cases where there's a decrease in privacy protection. The other case that Christina has mentioned was a case where there is an increase in privacy protection. We'll come back to that. But in all of these, unless there will be a kind of manifest deviation from what is required from privacy protection, a competition authority, the authority, for instance, is not the best place to judge or to assess whether there is compliance or not with the privacy rules. And here there is really a need for coherence and for cooperation with the privacy agency, as CNIL in France, for instance. So in France, there are a number of settings that we use to cooperate both formally and informally. So in the French Code de Commerce, there are provisions which call for information to be transferred to CNIL, for instance, when there are cases which deal with these kind of issues, so that CNIL could provide with an opinion the authority in the case. That's what happened, for instance, in the Apple case. There are also other tools, and I'm not going to mention them, which enables some formal cooperation between CNIL and the authority, as we also, to some extent, actually to a great extent, not to some extent, cooperate informally by exchanging staff or having exchanges of views on key policy aspects. We have also actually produced joint studies or contributed to studies by the agency in the digital world. The last one was about the smart speakers, or smart assistants. To turn on the Apple case, which is, I think, an interesting illustration of that. So for those of you who use an iPhone, in June 2020, Apple announced that it would launch a new Apple tracking transparency framework, which basically that means that when you download a new app on your iPhone, then there will be a pop-up window asking you for consent if the app in question wants to use your personal data with third parties to raise advertising revenues. And this pop-up window is actually a standardized text window with obviously some key aspects which depend on the app. And then there might be a second window behind with specific information about the app itself. So there was a complaint asking for interim measures before the authority, where the complainants were saying, well, with this, that's going to create a bias against apps which rely on advertising revenue, and that's going to harm our business models, and therefore that's going to create some kind of exploitative abuse on the part of Apple. And they were asking for interim measures. We rejected that call for interim measures, but kept the case nevertheless. I will explain why in mid-March this year. So why did we reject it? First, we based on the opinion from CNIL, so the Privacy Protection Agency, we concluded that what Apple was providing as a change actually was providing users with more control, or would facilitate control by users on their privacy settings. So therefore it was a legitimate objective. And second, it was not precluded by regulation. And lastly, that appeared to be a proportionate way to achieve that objective. Nevertheless, we kept some aspects because there was a possibility that there would be some aspects of self-preferencing on the part of Apple with the new settings. So really what is important there is that there was some kind of, I wouldn't have to say integration, but there was really a level of coherence and calling for input from the agency which knows about privacy protection into that case. And that's, that's really, I think, a good example. That's something on which we will go even deeper, I guess, in the future. Turning now to the ICM, and I will speed up on that because I can see that the clock is ticking. But turning on the ICM, the idea there in the steering committee, which was launched last year, and I should say that the authority is not steering that steering committee at all. I just happened to be sitting in one of the webinars on dealing with that. But the idea was really to make sure that the various national ways or federal ways to try to ensure both coherence and solve tensions when there are tensions would be shared, to take stock in the first phase of the various ways to deal with that. And once that would be done in a second stage, presumably perhaps next year, to provide some soft guidance or soft ways or recipes on how this has been some key principles that maybe should be respected or should be looked at when trying to resolve that at national level. I think I would stop there so that there is enough time for people to interact.
Thank you. And I think that we are moving close to the end in that, as I predicted, all of you are so interesting and have so many interesting things to say that it's hard to stop you and to interrupt and really difficult to do more. But I want to use the last few minutes really to give very briefly each of you, to the extent that you wish, the opportunity to make a final comment or statement or something that you heard that you wanted to pick up, and then I'll wrap up together with Johnny. Maybe Andrea, do you want to go first? You don't? No, fine. Anyone who may have any follow-up or last thoughts, including you, Johnny?
Yeah, Christina, maybe one very last word on this.
Thank you.
We are competition people, we know competition law for years. And if we want to do these kind of cases, we need privacy people, we need them. And we couldn't have written these 100 pages in the middle of the Facebook decision without the privacy people over here in Germany, in Hamburg, but also here in Bonn, our colleagues. I just wanted to mention that once more, also with regard what Wojciech has said. I still remember that event very well together with Giovanni Buttarelli. Same last time I saw him, at least on the screen, and he's right. Since then, we haven't had such substantial meetings in the past, and again, we cannot do that on our own behalf. I mean, again, we are competition people. We need help. That's as easy as that.
And it's important that you say that because, of course, again, we have here on this panel the most enlightened agency leadership that really sees that. It isn't something that I see broadly, let's put it that way. It is not something which is yet widely shared. And so that's the purpose of this event, to really kind of put forward the position that you guys are really ahead and really see this as something that really is happening. And so my objective in that of Greg and others in this event was really to motivate people who are not quite on the same page to really see what's happening on the enforcement side, coming together with these perspectives, and ultimately also from the economist perspective to kind of stop thinking that, you know, I'm not completely sure I agree with your framing, Henri, because market failure, I mean, what is market power if not a market failure in a way? So I want people to really do think about that and not sit in the sideline and say, we do just antitrust, we are the sort of the IO economists. So let me just, Elizabeth, you had your hand up. Do you want to make a final comment?
Yeah, thank you, Christina. I mean, I think what's really important is there's urgency to this work. So if we're going to be relevant in our oversight of these large tech platforms, we have to work together. So I'm not naive. We know that there are tensions, but it is a lot of work to start breaking down the concepts, to understand the way competition authorities are thinking about digital markets, the way data protection authorities are responsible for protecting privacy. And, you know, I have come to the conclusion that we have a lot in common, but what do we do about the urgency of this work? And, you know, I do think that policymakers expect us to be working together. And so we have to get out of our silos and we have to be creative and innovative. But I just want to underscore, going back to Wojciech's comments, that, you know, the clearinghouse, those conversations started 8 years ago. And we're in a place now where we really have to get with the program and wake up and smell the coffee. So we just have to get on with this work.
Wonderful. Wonderful. Thank you for that. Wojciech, you have your hand up. You want to make a final comment before I hand over to Becca for the wrap up?
Yes, just one sentence. I don't want to be seen as somebody who is pessimistic. I'm the one who is asking, is my optimism well-grounded, and can I really see the things that we all expect to happen? So this is not pessimism. This is the question, where are the results?
Wonderful. I like you so much. Becca, so will you take it away and say one last word of wisdom for us?
I will try to do it in a concluding way. I think I agree with what Andrea said, that we need to not be just looking at this as a competition issue, pull in privacy perspectives. And I want to expand on that point to say, not only do privacy perspectives need to be integrated, the kinds of expertise we bring to the table needs to be evolved. So not just traditional IO economists, how they think about antitrust, but more technologists, more people with business expertise to think about how business decisions are being made and how we get to incentives there. And then further, and this is where I'll give you a wrap-up comment. I think we need to be working in a global way on these issues. The markets do not respect jurisdictional boundaries here, digital markets particularly. And so partnership, not just within any particular jurisdiction, like between the FTC and the states, but between global jurisdictions, I think is really important. And I am grateful to you for conferences like this that facilitate that kind of coordination and collaboration.
What else is there to say? I won't add to that. That's the perfect ending. We are 1 minute after time. Wonderful words. I'm so grateful to all of you, busy as you are, to have found the time to come and have this conversation. But I do believe it's an important conversation. And you are going to move the dial if you continue participating in this discussion. I'm grateful for your work and good luck to everyone. And thank you for joining this discussion. I'll leave it here.
Right. Thanks, Christina. Thanks, John.
Thank you, everybody.
Bye, everyone.
Bye.
Bye.